All right, so it's 12 o'clock by my count, and so we're going to go ahead and get started. I want to welcome everybody today to our seminar. My name is Brian Denny. I'm the current president of the Palm Beach ABOTA chapter. With me is our executive director, Kathy Cleveland, and also our membership chair, Ian Robinson. And we're pleased to partner with FLABOTA today in hosting today's seminar of do's and don'ts of opening statements and closing arguments. This is a lot to cover in the time we have allotted. So we might go over an hour, but we don't have to. If you do have questions, feel free to put them in the chat, either at the end. We'll ask them at the end, and we'll see how good the speakers are picking up any of your questions during the talks. But on that note, I'm very excited to introduce two of the most respected trial lawyers in Florida, Dan Santinello and Greg Barnhart. They're both ABOTA members and true stalwarts of the courtroom. From the defense side, Dan is the managing partner of Lux Santinello. He's a board certified civil trial lawyer with over 25 years of experience. He's done over 140 jury trials to verdict. He leads his firm's parachute trial team, which handles high stakes litigation across Florida and certain parts of the country. And he's widely recognized for his expertise in catastrophic loss and liability cases. From the plaintiff's side, Greg Barnhart is my partner at Searcy, Denny, Scarola, Barnhart, and Shipley. He's tried well over 100 cases. He's a member of the prestigious International Academy of Trial Lawyers. He's the former president of the Florida Justice Association. He's an excellent trial lawyer. I've had an opportunity to try a case with him. He's a leader in trial advocacy and lectures yearly to the Florida Bar Board Certification Review course on these very subjects that we're going to talk about here today. So I think y'all are going to be in for a real treat, listening to two different perspectives from the plaintiff and the defense on these subjects. So with that, I'll turn it over to Dan and Greg. Take it away, guys.
Thank you, Brian, for that
Thank you, Brian.
introduction. So Greg and I are gonna, I do defense 100%. Greg does a lot of plaintiff 100%, and we're gonna do our best today to kind of moderate a couple issues for you, do's and don'ts on the opening and closings, and try to get some strategy in there too. If you've got any questions, we could take real-time questions only by chat, and Kathy at FLABOTA may be able to open it up for verbal questions afterwards. And I see David Prather is already giving us accolades, Greg, and we haven't said one word yet. So thank you.
He just wants to be recognized. Hello, David.
So look, I mean, I think that Greg, and there's a lot to be said about the do's, but there's a lot more to be said about the don'ts.
I agree.
To talk about the do's, on the plaintiff side, you guys always get to go first, which I like, and that's going to apply for this presentation today, Greg. But
okay.
What do you think your key do's are for putting on your opening statement for jury?
Well, the first thing we have is a clear theme, but I think even more basic than that is every case is a story. And if you're a good storyteller, and trial lawyers, particularly highly successful trial lawyers, are good storytellers, you need to put your case in a story that makes sense, is compelling, and moves you. So that means, number one, don't read it. Don't be tied to notes. Don't be tied to a PowerPoint, which is among the most boring things you can do to a jury. I do like using visual aids. I personally don't use the lectern. I write it in handwriting on the big graphs, the big tablets. I'll make some outlines, and that guides me. And I memorize the first 2 or 3 minutes and the last 2 or 3 minutes. But what you want to do is you want to talk about things and I do use exhibits, and I go back and forth, and I try to get the jury to follow us. If you use a reasonable tone as opposed to an argumentative tone, you can usually say what you want to say within reason. And when I say what you want to say, you can continue your story. You have to acknowledge the defense. You have to say they're going to do a very good job. Whatever issues you have, and every case that goes to trial has issues, you have to first emphasize the positive things in your case. So highlighting critical evidence is very important. And then for those things that are weaknesses, you can't have an aha moment. You can't have somebody like Dan take something that you forgot to say or that you forgot to bring up and ram it into your stomach. It's one of those things that is really difficult. And then, I think the most important thing is as you finish, you want to make your client likable. You want to, if your client is a tough person and they're not going to make a great witness, I think you need to address that and say, some people are just really, they get so intimidated about being in court. It's very difficult, and then go forward like that. I always address the defense as doing a very good job, and you'll go through it and try to get people, the jury, to see the case, because you're not going to win the case in opening. You might lose it. I think you win your case more in voir dire if you get a bad jury. But if you get a, sort of an average jury, you need to get them on the story. You need to get them to start to maybe not believe the story, but understand it. And then if the defense has whatever issues they have, whatever defenses you have, you need to address them. And then you have to address damages in some fashion. Do I use numbers? It depends. A good defense lawyer, if you ask for $10 million and the case is not worth $10 million, will shove it up your rear end. So it just depends on what you do. That you have to use judgment for, and it depends upon the case. So that's the way I approach opening. Dan, what about you?
Look, I agree with all of that. Big question I was going to ask you is, are you going to try to anchor in opening? I'll start there. I mean, I look at the three most pivotal parts of a case are going to be jury selection. I think opening is critical. There's a study, and I can't cite it out there, where they used focus groups, and they just did openings, and then they used focus groups to do the opening and closing, and the verdicts were very similar. So the baking occurred in opening.
Right.
And I could tell you, as a 35-year defense attorney, I have a little more angst when a plaintiff counsel is using more exhibits in opening, because I don't like the jury seeing a lot of evidence in opening. I generally don't anchor in opening. My position is I would tell my jury that they haven't heard the evidence yet, and what the lawyer is saying is not evidence, and the judge will tell them that. And I think it's out of respect for them and the job that they have to decide a case solely on the evidence and the law that's given, that I will save my discussion, if we have one, on damages for closing argument. So when if a plaintiff attorney tries to anchor with a big number or a number in opening, I'm going to try to turn that on them from a strategy standpoint. But I agree with you. You got to use some visual aids, guys. I'm not impressed with PowerPoint openings, but I get it. A lot of people use their second chair for openings, and second chairs might not know how to dance like first chairs know how to dance. But I would definitely use some visuals, because the attention spans have changed. I mean, you look at your cell phone today, it's hard to sit down for dinner and have a conversation without taking a peek at your cell phone. I get that from my wife every night. David asked us a good question, and for the young people here, what is anchoring? And anchoring is that strategy where you plant that seed early on the numbers. You plan it early and you plan it often. Do you do any anchoring, Greg? You mentioned sometimes you discuss numbers, but you do any anchoring in the opening itself?
Yeah, more on liability. So I tried a wrongful death case and we did very well. And I started out by saying, this is a love story. And it's a story about a mom and a dad who loved their little boy and had their hearts ripped out, and then continued that. So that anchored sort of the theme of our case all the way through, and then brought it back in both closing and in rebuttal. So, you know, if it's a smaller case, not really. Now, in some cases, like a baby brain damage case, which I've tried a lot of, where you do have numbers that are astronomical, economic numbers, then you do bring that up. And but you don't, I don't really try to do that. Anchoring is thank you, Dennis. Anchoring is when you try and instill an idea that anchors or holds, like an anchor holds a boat, with the jury in their mind for the remainder of the case. And then you remind them and so on. That's
Yeah, a lot of people don't realize that, Greg, that
Yeah.
anchoring isn't just about dollars. Anchoring is about allocation of fault. Anchoring is about key themes in the case. And we're always trying to drop anchors. You're doing it, we're doing it on the defense side.
Right.
And the question is, you know, what is your anchoring strategy? I think anybody that tries a case nowadays needs to have an anchoring strategy for liability, Fabre allocations, fault allocations, damages, comparative. And, you know, I'd say to my defense side, if you don't anchor in numbers in closing, and not everyone will agree with me on this, I think it's borderline below standard of care not to anchor a number in closing, because then you're giving it to 6 people who may or may not understand numbers like we do, giving it to 6 people to just take it out of thin air or take the plaintiff's anchor. So, I mean, Greg, I'm curious, do you have, for the plaintiff side, do you have a thought on giving the jury a range or a dollar amount in opening?
In opening, usually not unless the damages are very high. I'll usually say that the evidence will show that it's a multi-million-dollar case or whatever it may be, but I don't usually give them that. And for the reasons we discussed, a good lawyer like Dan, if things don't go well, if experts don't do as well as we thought, if your client doesn't do it as well as we're not, they'll make fun of. Yeah, this is a $5 million case. Yeah, well, you know, and that you really, I'm more careful about that than with giving numbers and opening. I mean, it happens. I mean,
What about the law? Are you going to go through? I mean, you got to go through basic law and opening.
Oh yeah, I agree with that. I do. So we have to talk about the standard of care, whatever it may be. I mean, if it's just negligence, then it's carelessness and that sort of thing. And we do talk about it. Sympathy and prejudice, I don't talk about in opening. In closing, I do. I mean, I say we're not here for sympathy. We're here for justice. And you'll hear that sympathy is not what you reward, it's not what you bring compensation for, but you do it for justice. What was taken from Mr. Plaintiff or Mrs. Plaintiff, or ripped their hearts out with the death of their child. And, you know, so a good defense lawyer in a wrongful death case will talk about, well, all the money in the world won't bring this little boy back or their wife back or their husband back.
Yeah.
And in the beginning and closing, and not in opening, but in the beginning and closing, I say that all the money in the world's not going to bring their loved one back. But that's not why we're here. We're not here for sympathy. We're here for justice. And then I explain how justice applies. And the purpose of the law is to compensate for what was taken. Then we're going to jump into this, but whatever you do in a wrongful death case, don't talk about the value of a human life. Don't do it, because that is instant reversible error.
Golden rule 101. So sympathy and prejudice for the defense side, for me personally, that's my best instruction, right?
Yeah, it is.
My job is to try to get a jury of 6 that are human beings and can put aside sympathy and prejudice for or against any party and decide the case solely on the evidence. Something, in my opinion, a human being can't do. unless they've committed to doing their best, because it's very difficult. So I do spend a lot of time on sympathy and prejudice and jury selection. I do an opening, and it's my closing part in closing. It's where I kind of end my case, and I think it's very important. And so I think from, for the trial lawyers or the young trial lawyers out there, there's basic instructions you can cover in opening, but you haven't had a charge conference yet. So be careful, because if you go over law that doesn't come in, you could be looking at a problem there. You mentioned the golden rule, Greg.
Yeah.
So let's talk about the don'ts, because to me, when I pick up a bad verdict, meaning maybe I get hired to look at it post-trial, or I'm looking at a bad verdict, and my experience as a trial lawyer, and I don't do the appellate stuff, one of the first things I want to look at for my best appellate arguments is closing statements. That's where things go wrong. So let's pivot a little bit here, Greg, and talk a little bit about the don'ts. And the golden rule is a big one you just mentioned. What are your thoughts?
Yeah. So golden rule, just for those of you who may not be fully up to date on it, golden rule is asking the jury to decide the case as if it were their case or their injury or they were being sued. So of the cases involving golden rule, of which there are many, about half are defense lawyers violating the golden rule, about half are plaintiffs' lawyers. So you cannot ask someone, either plaintiff or defendant, to decide the case the way they would want a case against them or for them to be decided, right? So that's pretty clear in the South. In the North, the golden rule is pretty much acceptable. What's not acceptable are per diem arguments up north. I tried a case in New Jersey. You can't even ask for a specific amount of money other than economic damages. So golden rule is easy to transgress, and you have to be very careful about it. And when you start using words like I or that sort of thing, then you need to be careful about it. And if you're a little bit unsure about the golden rule, read about it before you try your case.
Yeah.
What do you think, Dan?
Well, look, a direct golden rule violation, you could spot that, easily.
Yeah.
Like, what would you want for your injury if you were the plaintiff? You do that, case is over, right? The indirect ones are the ones you've got to be careful. So some of you may recall the magic button case. Like, if the plaintiff were offered $6 million or a magic button to have their son back, what do you think they would do? They'd hit the magic button. That's a golden rule violation. That's reversible, because you're making the jury think, what would I do? Hit the magic button or take the $6 million? That's the same with the injured puppy case, which happened to be our law firm, by the way, 15 years ago. But the injured puppy case was, the plaintiff has a disability. He goes to the pet store and he buys an injured puppy, even though there's healthy puppies, because he knows that no one's going to be able to help this injured puppy but him. That's a golden rule violation, because it makes the jury think about, gee, what if I was that injured puppy? Who's going to take care of me? So those are the indirect golden rule violations I think you have to be careful of. And, the best thing I could tell younger trial lawyers is, if your gut tells you you're crossing the line, you're crossing the line. I mean, when it doesn't feel right. You just have to know when to bite your tongue,
Right.
in my opinion.
And it's the personal stories, right? When I or Dan start talking about telling my wife in a wrongful death case that I really loved her for the first time in a long time, that's the kind of stuff that gets you reversed. Because I jumped around, but it's comments on matters outside the evidence. Or I played football at UF, and I know, that kind of thing. I tried a case against a lawyer who did that. He didn't win, but it didn't matter. Maybe they were Florida State fans or something, but those are the kinds of things I completely agree with Dan. If it sort of feels like you're sliding into it, And here's the thing about closing, right? Opening, yeah, you're pretty prepared for, or you should be anyway. Closing, if particularly in a longer trial, you're tired, and then your adrenaline is kicking in. And lawyers, look, lawyers are natural talkers, or natural, at least trial lawyers, and they're sort of natural storytellers, and they're natural arguers, and you get carried away. And adrenaline and a bunch of coffee can make you transgress, and you don't want that. And so
Yeah, some people,
yeah, go ahead.
so, I mean, some people, it's like you're in the final 10 minutes and you're like, I just want to win, right? It's been 2 weeks. But,
Yeah.
Brian had a good question for you, Greg. And I honestly think this is the toughest question we'll get today. So kudos to you, Brian, for this question, because it's a tough question. Like, how do you, say on a death case, talk about the value of a human life without crossing the line? Because damn, you got to get real close to it.
Well, you do. I immediately go into, we're not here for sympathy, because you can have sympathy, but that's not what the case is based upon. The case is based upon what was taken from them. And I go into a little bit of history of the law, and the law is to compensate for that which was taken. And we can't, all the money in the world cannot bring back whomever. All the money in the world can't do anything, but you 6 people can right a wrong. And when you right a wrong, you need to make it fair. And what would be fair under the circumstances? For the loss of this wife or this husband or this child, what would make it fair is $10 million or whatever it may be. For death cases, I never use a per diem, ever. I don't think it's appropriate. It sounds mercenary or mercantile.
I agree.
Yeah.
I agree. I'm not a big fan of per diem, and I wish we could eliminate it, but that's for the legislature, not for me, right? You did also comment on, Greg, on the matters outside the evidence, and you got to stick with the evidence, guys. If you start talking about things that are outside the evidence, like you could get in trouble. Now, I think it's fair game to say, why didn't we have any treatment in 2024? Why didn't we have this in 2023?
That's fair.
That's fair game,
yeah.
Right? But you've got to be careful there. And I think in this day and age where we've seen the advancement of reptile, and that's the second bullet point here, from my position, there are a lot of reptile arguments that do cross into golden rule. For example, like, don't you think that your driver going 10 miles per hour over the speed limit endangers the community? I don't know. I think if you made that argument in an opening or closing statement, not on cross-examination of a driver, you could be looking at a potential appellate issue there, because it's endangering the community is a conscience of the community argument. That's why we defense attorneys get so excited about the reptile strategies that are employed in deposition, because they sure as hell taste good in depo, but how they're used in trial can become very risky in not overturning that verdict. Any thoughts on that, Greg?
Yeah. So conscience of the community is an argument where a lawyer argues that the jury should make the decision based upon what's good for the community, Jacksonville or Okeechobee or whatever it is, as opposed to the law, right? So there are a number of cases about, cruise ships and fairs and things like that, hunting, where lawyers, defense as well as plaintiffs, talk about, encourage the jury to make a decision on what would be good for us, as opposed to what's appropriate under the law. And the law is very clear. The conscience of the community is not the standard on which a verdict can depend. And it's easy to sort of just sort of side into it. But that one, you sort of have to, that one's not as easy. Golden rule is a little easier to screw up. Conscience of the community, most people think about it. But the reptile stuff, so reptile's based on essentially people getting mad, right? And people being jurors, and jurors who are mad tend to return big verdicts. They're not going to get really mad usually at somebody with a herniated disc and, who are rear-ended, but they can get mad about other things. And, you do try to encourage some anger, but you got to be careful about the way you do it. So look, one other thing I wanted to say is our Supreme Court has 7 justices. Do you know how many have tried a case? 1. 6 have not. The new appellate court judges tend to be, many of them are young, a lot of them are smart, but like in the 4th district, where a lot of our cases are, there are a number who have tried cases, but the number who have not outnumber them. So as a trial lawyer, there are some very good appellate lawyers. And if you say something in a 2 or 3 week trial that truly does not, it doesn't make that much difference to the jury, a skillful appellate lawyer can make it sound like that is what rang the bell.
Yeah.
And so we need to be even more careful, really.
No, we do. And it's sad but true, but good trial lawyers know how to get to the line and not cross it and be respectful to each other on the rules and the ethics and that. I love trying a case against a good trial lawyer. With this new mixed comparative statute, the last bullet point in this slide before we jump to the next one is encouraging the jury to deviate from its duty.
All right.
And with this new mixed comparative statute and the committee saying that the jury is entitled to know the effect of finding a plaintiff more than 50% at fault, I think for trial lawyers, be careful, and defense trial lawyers, be aware. You can argue that, if the plaintiff is more than 50% at fault, they don't recover in the case. But what you can't say is that, you'll be giving this plaintiff nothing if you find him over 50%. To me, those are 2 different ways to argue it. Any thoughts on that one, Greg?
Yeah. Under the new one, the jury instructions under comparative fault, Slauson versus fast foods and others, you could talk about the effect of it, which makes sense because you don't want to delude the jury. So under the new partial contributory negligence statute, so the jury instructions say you can argue the effect of it. I think you're not doing your client a good job if you don't argue it.
I agree, but where you might cross the line is where you say you'll be hurting them and zipping them, giving them nothing if you do over 50%. I mean, you can't suggest that they should deviate from their duty just to not leave them.
Yeah, that's where I do part company on that one. I think if you say, look, if you find them 51%, then they've recovered nothing. I'm
okay with that.
Yeah, okay.
I'm okay with that. What I'm concerned is with the attorneys that will suggest you'll be leaving them with nothing. If you
okay.
You
mean go overboard? Yeah, I can see that.
It's a nuance where you're suggesting don't do it, not because the facts and evidence support it, but because it will put them in jeopardy. It'll put them in harm's way. It'll put them in a destitute position.
I agree.
This other new rule is scary. This new 1.380 paren D2 now allows, if you get judicial permission, and I haven't heard of a case yet where this played out, you to comment on a party's, failure to engage in some sort of discovery violation. And that one blows me away because that has never been fair game. How the parties litigate, how long they waited to admit liability, none of that tends to prove or disprove who caused the accident, what the reasonable damages are, in my opinion. You got any thoughts on this new rule?
Mine too. The law is very clear that discovery violations are for the court, not for the jury. And if the defense admitted liability on the day of the trial, you can't talk about that because that's pretrial. You can't talk about somebody being held in contempt or something like that because that's for the court. I really think that trial judges, particularly experienced trial judges, are going to be very reluctant to allow this to be discussed. Because there's a case, it was a tobacco case, and we tried a lot of tobacco cases. Out of the fourth DCA, that said, there was one lawyer they didn't like, and he'd used a number, he was a good lawyer, he's a friend of mine actually, but he'd used a number of literary analogies in different cases. And they said, if you keep going on, or a lawyer keeps going on, then the judge can instruct or tell the jury about it. Well, that was 5 years ago.
Yeah.
To my knowledge, no judge, no trial judge has ever done that. It's a dirty pool. It's wrong. Anyway, to say that, I think that rule is going to be, look, if I were on the defense or I was on the plaintiff side and I was moving for that, I'd be very careful about that. Do you
I
really
agree.
want it? You really
I-
want it?
I agree. It's one of those things that I think we should just never change in the practice of law. That last bullet point, expressing personal opinions, is another one that gets people in trouble. You know, some people think just because you say, I believe this witness was not credible, that's a personal opinion. It's borderline. And I tend to find trial lawyers have a big problem kind of translating it from I think and I believe. But you got to be very careful here. Like if you vouch for a witness, you're done. It's reversible, right?
It is. It is. It's people saying things like, this is the most honest witness I've ever had. I've really not had a better client than this in my, that kind of thing, because, well, number one, so we get ethics credit. That violates the rules of professional conduct. Why? Because you're not a witness. You can't give your personal opinion.
Can't be cross-examined. I can't cross-examine
Right.
you if you say
No,
that.
you can't. You can't. And those are the kinds of things to say because we all use that. And there was a judge in Stewart that kept, he was just like a nut on things like that. And the judge said, the appellate court said just using I doesn't do it. But if it's, I think that this is the best witness I've ever seen, or this is the most compelling case I've ever seen, you know what? You might as well say, okay, judge, we're going to retry this case because you are.
But there is some case law that allows you to say, I think the evidence is such that we've proved our burden. You can barely touch.
Oh yeah. Yeah, that's a little different though. Then you
But don't do it.
Yeah.
I don't think you should do it. But some people those are Freudian slips that you sometimes can't control
I agree.
at the podium, in the heat of the argument, and you just have to turn that ship back. Especially if you take an objection, you say, I'm sorry, and rephrase it, in my opinion, because that is a Freudian slip. The other thing I see is sometimes lawyers hate each other, right? They say families kill each other for money and wills. What do paid professionals like lawyers do? And there's one thing I have a high level of respect for my adversaries. And even if I don't think that they're performing ethically in the trial, but if you go after the lawyer, you're in dangerous waters, right, Greg?
I agree with that. They're not the party. And when you go after them, what you're doing is you're commenting on matters outside the evidence, because the character of the other lawyer or whatever they say is not an issue. Plus, it's also kind of dumb, I think. You only have so much time. Why go after another lawyer?
Yeah.
I mean, most of the cases I try and are, the lawyers I have great respect for, some more than others, but we get along, we're not enemies. There were times Brian and I, in our firm, there were some tobacco lawyers, not most, but some, who I really didn't care for, because I didn't care for their antics and I didn't care for what I thought were issues that crossed the line. But you can't bring that into court, if you do, you do it to the prejudice of your client.
You really can't. And I think, an example that comes to mind, because, look, I could be a little aggressive on cross-examination, especially against an expert who I think is in the bag.
Right.
And, I've had some attorneys say, look at the way he went after my client, or look at the way he went and I'm going to be all over that. I'm setting that up for a mistrial, which we'll talk about preservation in a couple of slides. But, I'm setting that up for appeal, because my perspective is a good trial lawyer should have 3 good appellate issues in a case. And because you don't know what the verdict's going to be. So don't attack personal counsel. I think that's a no-brainer. Misstating the law I mean, it's happened, but again, Greg, big problem if you go in and mistake the law, right?
Yeah, don't do it. I mean, you figure it out. You're a lawyer, get it right. The
Yeah.
one thing when it comes to some of these experts who are, we know them, they're on both sides. You can certainly talk about how much money they have made if you've asked those questions, right? If somebody's made $1 million, you can say they were made $1 million from State Farm or whatever.
Yeah.
But you can't call them this whore, this prostitute, this
Hired gun.
fool, that kind of stuff, hire gun. You have to back off on that. Let the jury draw their own conclusion. And you don't have to you really don't have to use a noun. Just talk about them and you get it. $1 million. Yeah, okay.
Look at that last bullet point. I tried a case 3 times against Trey Lytle, and we get along great. But the first trial, I licked him pretty good, but my cross to the plaintiff was, you sued this Fabre, didn't you? And the third district said that might have made the jury think they settled, and they reversed that one.
Yeah.
So you can never bring out that someone settled unless some major door has been opened. But my advice for the defense side in those situations, because a lot of times plaintiffs will shotgun sue everybody, and then they give interrogatory answers incorporating the allegations of their complaint against everybody. And I'm figuring out how to try to use that to my advantage in my Fabre defense, right? That I have the burden of proving. And so, what the third told me I should have done in that situation, even though her sworn answers to interrogatories incorporated her allegations against the Fabre and the complaint, said you should have said you blamed, not sued. You blamed at one point. So any thoughts on
I
Fabre?
do have some. Those are so that it has to do with empty chair arguments and potential settlements. And so the law is really clear based on public policy, right? So what's the public policy that the state wants? Well, you want people to settle cases, right? It's like it has to do it's almost like the traffic citation and that public policy. They want people to drive safely and be honest in talking to police officers. All right, so settlement. You can point to an empty chair, meaning there's a chair in the courtroom, the defense is here, there's another chair over there, and you say, well, no, wait a minute. The person who really is at fault is so-and-so, but they're not here. But you've got to be very careful, particularly on the defense, because this is really a defense argument. If you hint that there was once a party and they settled, then you're going to get reversed. I mean, that was the case you talked about was subtle, but it was part of that public policy. So you've got to be really careful about that. You can blame somebody else if you're a defendant. You certainly can do that. But you just can't use any kind of language that talks about potential settlements.
Guys, can I jump in and ask you a question for a minute, especially for lawyers? Opening statement and closing arguments. Those are really the 2 times in the trial where no one's talking back at you. You don't have a witness that might be saying something unpredictable. You don't have jurors during jury selection. They're saying something unpredictable. So how do you, I know what I do. I rehearse my opening statements in front of folks that aren't afraid to be critical of me so that I can edit out some of these don'ts that you all listed up here. So how do you prepare for that? Do you all do the same thing? Do you write them out? Can you speak to that just for a minute, just so some of the folks here can get a sense on how you do that?
Yeah, Greg, you're first there.
Okay, I will. So I practice. And in fact, my wife has seen me try a lot of cases, usually just opening or closing. She doesn't watch the whole trial. And it just not all by any means, because I've tried a lot. But what she said one time was, if secretaries and stuff were going, oh, Mr. Barnhart, that was great. And then she said, well, Greg, you're better when you practice. And I said, you're right, I am. And I think that if you do it in front of, I like the idea that you do it, Brian. If people say, that doesn't make sense, I don't buy that. or that's not winning it. I think that's great. You don't always have the luxury of that. But with opening, you know, if you practice it, if you feel good about that, that's good. Closing, you don't usually have that time. You know, yeah. If you and I are trying to case, Brian's, I'm going to do rebuttal, you're going to do the original part. We talk about it, but the actual language you can't. But the more you prepare, like it's anything else, right? Golf, tennis, whatever. The more you practice, the better you are, right?
Yeah. Yeah,
So,
it's true. I mean, I don't ever wing an opening. I have an outline. There are key points I'm always going to cover. Sympathy, prejudice, what I think the evidence is going to show. I'm not going to get too argumentative because Greg might have something in his back pocket he hasn't, filled me in on yet and during discovery. So I'm not going to put myself in a bad position. But I'm always going to tell the jury, listen, this is how we kind of see it coming in, and this is what we think it will show. If I know I've got the plaintiff on 7 good impeachments, I'm not going to lay him out for the plaintiff to be prepared when I do it. I'm going to say, look, I think the evidence is going to show, that there may be inconsistencies in the plaintiff's position theory on this, and this, and we'll see how that plays out. Closing a lot different, I mean, as we switch gears here in the last 20 minutes, how to prepare a closing statement. That is the most, in my opinion, that is the most important function of a trial attorney, is the preparation and delivery of that closing statement. And the preparation should be 2 to 3 times. It should take you 2 to 3 times an amount of time to prep it than to close it. People are tired after a long trial.
yeah, they are.
But you better have a good evening to get that prep done. Starting with you, Greg, what do you think are some key points on preparing a good and persuasive closing statement?
I think now our cases are big enough, at least the ones that I try, so that we have at least 2 people there. It's been a long time since I tried a case by myself purely. And so like the case that Brian and I tried, so we spent time saying, all right, what are the things, and we talked about it. And then just talking about it helps you outline it. And then we split up different things. And I think the most important thing is you got to cover like the facts. You have to acknowledge that the jury has spent considerable time. You have to acknowledge what they're doing is important. I think that the kind of lawyers that give me the most heartburn are the kind of lawyers that I really like. I mean, likable people, juries like, I like. And that makes it a little bit harder. If somebody's hard edged and they've been taking cheap shots, and we try and take the high road and try not to object all that much. Can't always do that, but those are the folks that give me the most concern. But what we do is make an outline of it, and you got to cover what the jury's job is. You have to thank the jury without being condescending or anything like that. You need to, I compliment the defense usually, unless they're just idiots. And then you have to summarize the case in the way that you said it was going to be, so that in opening, so that the story that you're telling made complete sense. That the problems that you had, you talked about, and we talked about them, and we can do that. And then you talk about, liability. And I use the jury instructions and the jury verdict form as an outline and closing. And then I have it blown up and I fill it out, right, as I go along. And when it comes, so negligence is the first question. And we talk about what did they do wrong? And so I don't really say negligent, but negligence is carelessness. Or in a malpractice case, why didn't they do their job right? Well, they didn't do their job right because they weren't paying attention, or whatever it may be. Cover that, and then you go on to the causation questions and damages. And damages for the plaintiff, don't leave that to the last minute, because that's really important.
Oh, I love it when you do.
Yeah, right. I mean, that's what your client has hired you for. Yeah, to win the case, but that's where the rubber meets the road. So
Yes or no on PowerPoint, Greg?
occasionally we use some slides. Certainly we show evidence on it. No, I do not use PowerPoints.
Yes or no on reading transcripts or playing clips from videos that were played to the jury?
Yeah, if they're good, if they're killer,
Not all
I show
judges
them
will
up.
allow that though, right?
Yeah, right. I mean, I can show that up on an electronic screen. We use blow up still. We use multimedia because I think that's more interesting to people. I'm very wary of PowerPoints, maybe because we see so many of them. But I don't know. What do you about you, Dan?
Well, you know, closing to me is it. That's
Yeah.
this is my favorite part of the trial. Um, to me, I always want to start by bringing them back to jury selection. You guys, there were 40 of you here, and 6 got selected because you told us you could do the job, and the job is not easy. It's the toughest job in the courtroom. You've got to put sympathy sympathy for the plaintiff aside. You've got to put prejudice because I represent a company aside and decide this case solely on the evidence. And honestly, I don't know that that can be done. It's a very hard thing to do,
Yeah.
especially when you're representing an insurance company. So I bring them back to what they promised they would do, and then I get into the burden of proof, and the plaintiff had the burden of proof, and that they committed in jury selection. If plaintiff couldn't meet their burden of proof, they wouldn't coin toss it. They would tell them, I'm sorry, you haven't met your burden of proof. This is about proving the case because you're seeking money damages. It's not about what really happened. I wasn't there, you weren't there, nobody was there. I can't get in his body. I don't know what he's really feeling. It's about what the greater weight of the evidence shows. And that's how I do it. I think you've got to mix in key testimony, key sound bites, and not all at once. Like anyone who just goes down, this witness said that, this witness said that, you're putting the jury to sleep. So I'm more of a topic centric type of closing than a witness. This is what this witness said. That's what this witness said. When I'm covering whether it was permanent injury, I'm picking off sound bites. When I'm covering the need for future medical care, I'm picking off my themes and my sound bites. Never using a PowerPoint. I think that's a mistake because you need them to listen to you. So you need to throw up your position for a second, bring it down and say, did you guys see that? Think about that. Like you need to bring them back, in my opinion, to what you're trying to accomplish. From a defense standpoint, you got to go through the verdict form with them. You've got to. If you don't fill that out, then I think you're playing with fire. That's very, very important to me. And tempo, like golf. I don't know if you golf, Greg, but there is a tempo strategy in trial. There's going to be portions where you're quiet. There's going to be times when there's dead silence. And then there's going to be times where you really lay out your position. And I think tempo is very important in getting juries to really connect with your side of the case. Any thoughts on that?
Yeah, I agree. So that's sort of basic storytelling. And when you say tempo, it means, using a higher pitch, a louder pitch, a lower pitch, silence at times, pauses. I mean, the best speaker that I really remember was Barack Obama. And he didn't slur his words. He didn't speak that fast, but he spoke compellingly. And those are the kinds of things that are really good. And for those who can remember, President Reagan did the same thing. He was an actor, and they were both, in different ways, gifted public speakers, and they were compelling. So if you lose the jury's attention, you're not going to do very well. And if you're a plaintiff, you need to talk about the things that you anticipate the defense will say, like whatever their defenses are. And I list them, right? Whatever it may be. I talk about the greater weight of the evidence. We certainly use the verdict form, as we said. And then, there's a time, we usually tend to run out of time. but one of the cases I tried was a malpractice case that was really tough. And the defense lawyer for the first 45 minutes was just really good. He knew medicine. He was so compelling. But then he went on for another 20 or 30 minutes and it just sort of lost the jury. And, I got it. And actually, this is the one Brian and I tried. He just sort of lost people because he was too much in the weeds.
Yeah.
And yeah, so he had the jury's attention and he lost it. And then they're thinking, oh, God, I don't know. I don't know what they were thinking, but he didn't win. So I think those are really important things. And so my speaking style is different than yours. It's different from Brian's. It's different from David Prather's. But not one is better than the other. What is important is if you show your body, right? So your body is, you are sincere. If you're shaking or something, juries pick up on stuff like this. I think particularly women, if you're not sincere, they can sense it. If you're, if you're off, maybe you're nervous or something like that, but your tone of voice, your body, your gestures, all of those things are very important, very important. And there's an easier way to do that is, particularly when I was younger, I'd practice in front of a mirror. And, I don't know if it helped, but it didn't hurt. And those are the kinds of things that help you get better. And, having other people, watching other people helps too.
Yeah, I could never do a practice run, just ever. I've tried, I just don't have the passion, I'd rather do it for that first time so that passion
Yeah.
at a 10 out of 10, at least that's been my experience because, there is emotion, there has to be emotion involved in giving a closing statement, but it has to be, in my opinion, tempered emotion. You've got to show respect for the process. It's the jury's
Right.
decision. It's not your decision. It's the jury's decision, and you've got to show respect for the process. But no, I mean, I think those are all good points. I also like the common sense. I think the common sense instruction is good for defendants because, use your common sense as Latin for this is the only time you can go outside the evidence, right? And jurors want to go outside the evidence. So I think that's a big one. And of course, we talked about this, the anchor and how to counter it. Look, I'm not an expert on how to counter an anchor. I've had many cases where a plaintiff came in, I tried a death case of an only child in Jacksonville against a good law firm, and they asked for 50 million. And I'm like, you know what? I got to pick an anchor. So I picked a mill. And it was the only child, right? So, how are you going to really sit there and explain that the mother's only worth a mill for her only child? In that case, I made a decision that might not play well, so I was just going to go with the number. It worked for me. We got a 95% comparative and a $1.50 on they gave 3 mil, but it ended up being a $1.50. So that I don't know what you think about that, but that's my position on the defense is this is a big controversy on the defense side right now is to try to deal with your per diem arguments that you guys are doing.
Yeah. So for the defense, I think it's probably better strategy to pick a number, but pick a legitimate number, not one that is so bargain basement it doesn't sound real.
Well, then you lose
Yeah.
credibility.
Yeah, I think so. You gain credibility by sounding reasonable. Per diems, that they're certainly, I mean, they're actually encouraged in Florida. You got to use them. Do they work in death cases? Not for me, they don't. Do they work in personal injury cases? Yeah, probably. You can use some, whatever the illustration is, minimum wage or whatever it may be. You can add it up, and it does sort of help. But per diems have been around since I've been practicing law, and jury verdicts vary. I think, I don't know. What do you think about you per diems?
I look, I mean, I tell the jury instruction ain't gonna say anything about per diem. It says there's no
Yeah.
standard. It should be fair and just in light of the evidence. And that, so that little formula you use, that's not what the law is. I mean, to me, that's the only way I can deal with it. In that regard. So in our last 5 minutes, Greg, to just finish up on, preserving issues for appeal, this is where most trial lawyers blow it. This is where I pick up a lot of files that went sideways, and I read that closing argument and I'm like, oh my God, and there's no objection. And thank God the defense would say for the fundamental, fundamental error doctrine in closing arguments. But, all I got to say is that if a lot of people don't want to interrupt, you have to do your job. And if it just doesn't feel right and it's wrong, objection, improper, you're going to hear either overruled or sustained, but you've preserved your objection. And you can, a lot of times I'll say curative, because I get a curative, great. That's a wrist slap to the plaintiff counsel, be a little bit cleaner. If I don't get a curative, I think I've made my appellate argument better. And you don't have to say much. Objection, improper, sustained, overruled, curative.
I do think though you need to move for a mistrial. And
you do, the question is, the rule is timely move for mistrial. So in my opinion, as soon as he's or she is done with that closing, I say, Judge, sidebar. And then I say, Judge, I got to move for mistrial, cumulative effect of all those objections. Some you sustain calls for mistrial. Now, do you think you have to do it right there and then? Because
I think under the Murphy case, I think you do. And so a lot of times the judge will say, because I don't like to object to the defense's closing argument, but sometimes you just have to. And I don't think the defense lawyers like to object to mine, but sometimes they have to. So if you move for a mistrial, I've had judges say, well, Mr. Barnhart, do you really want a mistrial? So then what do you say? You say, well,
yes.
Judge, you can reserve ruling until after the verdict, which is quite proper for them to do. Sometimes the judge plays chicken with you and says,
yeah, I call that bluff every day of the week.
well, I mean, if I'm a judge and we've been in trial for a while, I say, okay, well, I'll wait and see. If it's a 2 or 3 day trial, maybe. But the Murphy case is 25 years old. And, it's pretty clear. And there was a case, I can't recall the name of it, but it had every sort of argument error that you could possibly have, including others other than just closing argument opening. And the appellate court ended up saying, no, they didn't preserve it.
Yeah.
Even though all these things were errors, they didn't preserve it.
So if it's serious, I'll say sidebar for a motion. And if the judge says no, great. If the judge says okay.
Yeah, just say mistrial. Then you're preserved then.
Yeah.
I mean, the one thing that you got to be really careful about. So there are certain things you can't do. Can you compare the other side to a Nazi? No, you can't do it. Period. There's all sorts of cases on that. The more you get into that kind of thing, those are certain kinds of arguments you just cannot make. You can't do it.
Yeah.
And we have to preserve those. So anyway,
I mean, that's the hardest part of the game. Not the game, but the trial, I think, is that closing statement. I just see a lot of problems with closing statements because they're arguments. And when people argue, it's a different demeanor, it's a different approach than everything else that happens in the trial.
I couldn't agree more. And you've been on your feet for 20, 30, 40 minutes. It's pretty easy to sort of slide into something you shouldn't say. Right? That's why preparation is pretty good. But even so, there are cases where I'm thinking, oh God, did I screw this up? And I talk about the law on this. Usually I don't, but sometimes you get closer.
I think the other big problem I see is that a lot of people, you know, they don't ask for enough time. And then they rush, 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 rush. And I see a lot of defense attorneys, if I, you know, do a good job trying eviscerating their case, they come back and rebuttal and spend time trying to fix that rather than stay on course. But you got to ask for a sufficient amount of time. You can't do a closing argument in 30 minutes, in my opinion.
No, I agree.
If a judge tells you that's all you're getting,
Then you're
I'm
stuck.
going to set the record to show that's arbitrary and capricious. And why 30 minutes, judge? You know, I'll usually be funny and say, I want, you know, I want 30 minutes for every 5 million they ask for, you know. But I've said that before, judge. I should get 10 minutes per mil. Okay. But
Did that ever work?
oh, they laugh and then they give me the time I need. But I'm laying out the record and I'm trying to basically say, this isn't a 30-minute case. They're asking for real money. And this is important. And we've come this far. Let's get it right.
Yeah.
You know?
Well,
Yeah. It's
Dan and Greg, I hate to cut you guys off, and certainly not the intent. You guys have shared so much information with the group today, and we can't thank each of you enough for that. We do have a couple minutes to see if anyone that's out there watching has any questions for Dan and Greg to comment on. We'd welcome them now.
Sure. Thank you, Ian.
Hopefully, Greg, we won't have to do the dance together, but
Yeah.
we all know it. We all know each other's strategies now.
And if anyone has any questions, feel free to put them in the chat.
Okay.
Yeah, you guys can always reach out to me, at least my defense bar friends, being a past FDLA president. And Greg, it's been a true pleasure. And Brian, thank you for setting this up.
Well, you too, Dan. I mean, Scott, it's been, you know, we've had cases against each other. I don't think we've ever tried one, but we've never had a harsh word or anything like that. If
No,
you treat somebody like a pro, which you are, things work out, usually work out.
we should all be that way in this industry. There's no reason to make it more difficult than it has to be. But the truth is, Greg, your cases are always so big, I gotta settle them. So
I see a question here from the legendary David Prather directed towards Greg. Greg, how do you convey your numbers if you don't do a per diem?
Okay. I pick a number I think is fair. And I'll say 1.5 million or 2 million or whatever. And then we talk about the injury or the death and what this means to them. And usually I'll do pre and post, but I tend to like round numbers. Per diems, you know, when I tried smaller cases, I would use some. I don't know. I just felt like an accountant, you know, sort of going through it. And you know, David, it just didn't fit me. It just didn't fit me. And if it didn't fit me, it was like a cheap suit. I'd do it. You know, I think this case is, the evidence will show this case is worth 1 million, 1.5 million. Now you might think that's too low. You might think it's just right. You might think it's too high. It's up to you. But I think that's what the evidence shows. So things like that.
Well, thank you, Greg. I appreciate it.
yeah, I'll say from the defense side that in all my trials, I've seen the per diem about 10% of the time. So the people doing the per diem are in the minority, at least from my experience.
What I can see Mariano said, don't your numbers, what did he say?
He's joking.
Oh.
Mariano always has to get in the last word.
We have one other question directed to you, Dan. Dan, this is from Michelle Lynette. Dan, have you ever tried to anchor a number in opening or earlier than closing? If not, why not, if that is what you are going to do in closing?
So look, if a plaintiff comes out in opening with a huge number, I tend to find from my focus group strategies that if you anchor too early, the jury's going to think that you're conceding something on liability. So if I've got a good allocation or liability defense, I'm going to go back to the jury and say, I don't think it's right to give numbers to you. You haven't heard any of the evidence. And, you know, and I've already set this up in jury selection. I've said the plaintiff always goes first. Will you wait until we get a chance to go? Is it fair for the one team to get up to bat and the other team doesn't get up to bat? Is that right? No, it's not right. So opening, I'm gonna tell them, I'm gonna talk to you about numbers after I'm able to put on my case. I think that's the right way to do it. So I don't like to anchor an opening, especially if you've got a strong liability defense. And let's say that a jury just doesn't like your anchor out of the box. Well, guess what? On a 10-day trial, you've lost credibility in the first hour. So that's my position, Mike. Good to see you, by the way.
Those are some good points.
All right, everybody. Hey, thanks a lot, Greg. Thanks a lot, Dan, Kathy, Ian, FLABOTA, everybody for helping put this on. I hope this was informative. It sure was for me. I always learn something new listening to these folks. So thanks again for your time, gentlemen. And we've already applied for CLE credit for anyone still on the call. So we'll be reaching out to you as soon as we get word on that. I suspect that's not going to be an issue.
No, it won't be.
Everybody have a wonderful weekend.
Thanks, Brian. Thank you.
Thanks,
Thank you for
Brian.
having
Yes,
us. Thank you, Dan. Thank you, everybody.
Take care, Greg, Brian.
Bye, guys.
Bye.